In the Middle Ages, 500 to 1470. Introduction. Even after the Western Roman Empire collapsed, the Roman Catholic Church remained a predominant cultural and political power in Europe throughout the Middle Ages. It had a monopoly on the dissemination of written texts and the knowledge it contained before the advent of printing, and consequently exercised a significant influence on government and the law. However, this period also saw struggles between the church and the monarchy, and between the monarchy and its citizens for control of the law. Meanwhile, in Arabia in the 7th century, the Prophet Muhammad founded the religion of Islam. He told of a divine revelation of the words of God, which he began preaching in Mecca in 610 and continued until his death in 632. His followers collected the texts of the revelations in the Quran. The Prophet was also a skilled military and political leader, uniting warring tribes under a single constitution and amassing an army. Within a century of his death, Islam had spread from the Arabian Peninsula as far as South Asia and North Africa to create the Islamic Empire. Codifying religious law. The Islamic Empire developed a sophisticated legal system that was inspired by Muhammad's example and based on the study of the Quranic text. Muhammad's disciples had also recorded many hadith, sayings and actions ascribed to the Prophet and his family and companions. These hadith, once they had been verified by Islamic judges and legal scholars, provided commentary and interpretation of the Quran. Together with the Quran, hadith became the basis for what was to become Sharia or Islamic law. The Roman Catholic Church also formulated its own laws, known as canons. They governed the beliefs and behavior of mainly the clergy at first, but later of the congregation too. The Italian legal scholar Gratian was the first to compile the canons into a comprehensive treatise called Decretum Gratiani. It was the first of 6 texts collected into the Corpus Juris Canonici, which was completed by the 14th century, became the definitive reference of canon law. Islamic and Christian scholars also incorporated ideas from the classical Greek philosophers, such as the concept of natural law, into their cultures. Gratian in his Decretum said that natural law is, quote, the law common to all nations, unquote. Influenced by Aristotle, Italian theologian Thomas Aquinas examined the concept of law himself, especially the differences between the ecclesiastical laws of the church and civil law, which was not concerned with church affairs. He identified different types of law, from God-given divine and eternal laws to the natural law that exists universally, to laws devised by humans. His view that all types of law should conform to overarching natural law influenced legal thought for centuries to come. The law and the state. England's legal system was an example of the important changes that took place in the medieval period. Until the Norman invasion of 1066, Saxon rulers had enforced a hybrid of Viking and Christian laws, with summary justice and harsh punishments. The new king, William the Conqueror, took control of land ownership in a new feudal system. To do this, he made a detailed inventory of his realm in the Domesday Book, a record that would later supply precedents in property law cases. A significant innovation in the 12th century in England was the introduction of assize courts. These were convened from time to time in towns and cities presided over by traveling judges. Assizes wrested control of the law from the church and bolstered the idea of a common law. They also required local jurors to give evidence, and after trial by ordeal fell into disuse, the judge guillotined the precursor of the jury system. Another landmark in English came in 1215, when the barons negotiated a deal with King John, recorded in a document later called the Magna Carta. The king agreed that he would no longer act outside the law. The document also promised that every free man should have access to the law through the traveling assizes and could not be arrested or punished except by established legal procedure. While medieval Europe largely functioned under a dual system of civil and canon law, merchants had a greater influence on European society from the 13th century onward, instigating new commercial laws and even international agreements. These would prove vital to the further development of trade between nations and maintain their relevance until the modern era.